Mediation is fast becoming the better alternative to rigorous court processes in the country. Many people are now opting to seek mediation rather than go through courts, which, apart from being a rigorous exercise, is also very expensive. So what does mediation involve? What are some of the challenges that comes with it? Well, to understand more about this, we have Caleb Kusianya, who is a trained lawyer and now expert in handling mediation between parties, as well as Evans Wafula, who is an analyst and a journalist. Gentlemen, good morning and thank you for joining us on KTN News Center. Now, the Constitution of Kenya 2010 allowed for alternative dispute resolution, as opposed to court processes, to reduce the backlog of cases that has been witnessed. Kusianya, what has been the major cause or contributor of backlog of cases in the country to begin with?
First of all, in the judiciary we've not had enough number of magistrates and judges, right. And that has been one of the major contributions towards the case backlog, and also adjournments in courts. That has also contributed a lot in terms of the backlog of cases. Yes. Right.
I understand as of June 2018, we had more than 549,000 cases of backlog in courts countrywide. Wafula, in terms of mediation, as an alternative dispute resolution, why mediation and what is mediation?
Okay, if you look at, for example, the number of cases that we receive in our courts, they're mostly considered petty cases or petty offenders. And most of these people, the ones you see, they are so much piling up in pre-trial detentions, right. And before even the trials begin. And really, it's a big problem. And I think it's out of the consideration that most of these cases can actually be solved out of court. We have big cases, huge cases that don't even go to court, or maybe when they are caught, they are maybe even the bails are able to pay bails. But remember that most of the petty offenders cannot even pay bails because the bail terms are maybe so extravagant that they cannot be able to afford. So I think mediation works in the sense that considering the criminality, the case itself, the merits of the case, because there are cases like, I remember there was a case in Busia where it was a rape case or something like that, and the chief intervened. And almostly, to some extent, there was some kind of negotiations. Right. So we also to look at what kind of cases can warrant mediation. And also look at, for example, cases like corruption. I don't think you can warrant mediation in such cases. But look, many people in that category pay bail, they stay out, they're not able to go to even some don't attend court. But look at a chicken thief who cannot be able to raise bail and is put into pre-trial detention. I think that's a pretty good example of a case that can go through mediation. And that's one thing where I feel that mediation really needs to be put a lot of emphasis on mediation.
Right, because we're asking our viewers here, whether they would opt for mediation as a dispute resolution mechanism, and they say it depends on the weightiness of the matter. Kusianya, that then begs the question, who decides whether a case ends up in mediation?
The thing is, first of all, the public does not understand so much about mediation because right now it's when the judiciary is creating that awareness. Right. So what normally happens is, since 4th of April 2016, all matters that are filed in the family division and commercial division at Milimani at the High Court have to be screened. There's a mandatory screening of those cases for mediation. So once they're screened, then the mediation deputy registrar will determine which matters are suitable for mediation and which matters are not suitable for mediation. Right. Once they are suitable for mediation, then she appoints the mediator. She nominates 3 mediators to the parties in the case. Then they settle for one mediator. She appoints the mediator, and then the process begins.
And in this case, who is the mediator? Is it a party close to a member close to the parties? Is it a member of the judiciary?
No, not really. The mediator, you have to undergo training, first of all. Then once you're trained as a mediator and certified, you apply to the High Court, which then vets you and interviews you, then accredits you as a mediator. So once you're accredited, you're put in the list in the judiciary. Now that's where from the judiciary picks the mediators. and allocates the cases to them.
All right, all right. It's quite an elaborate process, but I feel like initially this was introduced in two divisions, the family division and the commercial division of the court. And when we began, you say a lot of these petty cases, would account for a majority of the backlog. When you take a look at the commercial division, for example, the judiciary argues when these cases are solved expeditiously, then they have the potential of releasing lots of resources to the economy because they could cost money, they cost billions, commercial cases. Yeah. What then would be the impact of that initially to society?
One of the things is that if you see civil proceedings, I think you as a lawyer will agree that in civil proceedings, I think there's a window for people to be able to deal with this outside court. But in criminal proceedings where, for example, even if it's a commercial matter where there's criminal liability, I think people have been allowed to pay or return. And I think there's also a division where they can recover assets for people who have maybe looted or criminal, who have been able to participate in offenses that are more of economic nature, so that you can recover the asset and the money and pump it back to the economy. There's a perception that if you steal a lot, or for example, people are involved in criminal matters, their cases are rushed so that they can be able to come out quickly, and then the money can be used. So I don't know where that knowledge comes from, but I think most important is that you see many of these cases have even taken a lot of time. Look at even people involved in Goldenberg, for example, which is an economic crime, and it went unresolved till now. So I think when you talk about mediation, I agree again is that it depends so much on the weight of the case, because many people, the government or the courts receives money from bails, and when you put people into pretrial without paying bails, also the government is not getting money. So I think the issue of the economic value of mediation, I think it is a two-way, because if people are able to pay bail and release, still there's an economic value. And if people are held and they're not able to still pay, it's also impacting also on the economy.
Right.
So I think both looking at it is that I think mediation should be accepted, should be allowed, and be only done in areas where there's no effect to the entire economy.
And even just talking about the economy and finances, because many cite mediation as a cheaper way as opposed to going through a rigorous and expensive court process. Yes. How is it cheaper, and why is it cheaper?
It's cheaper in the sense that, first of all, when you compare it with the court system, you realize that in the courts there's so many fees that you have to pay when you go to a lawyer, starting from instruction fees, drafting fees, filing fees, and so many more.
Right.
But by mediation, once a mediator is appointed, it's a very easy process. As it is right now, if you have a matter in court and you go through the mediation channel, you realize that you will not pay anything. The judiciary covers for that. But if you opt for out of court and you need a mediator from outside the court, you realize the fees is way less compared to a litigation, or rather the court system. And to just put in perspective what my colleague has said, in December 2017, during the mediation settlement week, during that week several civil courts came together to help the public resolve disputes. And they were from labor courts, environmental and land courts, and within that 1 week period, they settled about 2.9 billion worth of money in those cases, and that money went back to the economy.
Right.
And that just goes to show you how much mediation is helping the judiciary.
Right. But many questions still linger over mediation. What if we do not agree after a mediator has been appointed? What then happens to my case? What if I feel like, the other party has gained more than I did in this mediation process? Wafule?
I think in mediation, the element of criminality is eliminated. So that when you're entering into mediation, nobody is an accused, or nobody. The level of negotiation is about settlement. So you don't go into mediation with an element that you have committed you are the accused, or the other one is not the accused. So I think mostly what happens is that both groups have to agree that on a level that is a level playing ground. If you look at many family domestic problems, let's say family disputes, most of them, go to mediation because there's a common interest.
Yeah.
Most families fighting over property and over business management, they go to mediation because the common interest is established that it's a family business. So nobody has to lose and nobody has to win. So I think the element of getting into mediation without criminality is what I think is more important when it comes to mediation.
Yeah. Let's talk about then, because still in the family division, there's quite a lot of, it's a very thin line depending on culture, depending on religion. And, let's take the rape case that Wafula mentioned before. And in many, in Islam culture, for example, many would choose to solve this within the family. But then that still begs the question, what kind of cases then would go for mediation? Because rape cases being mediated have caused quite a lot of debate.
Yes. As it is right now, the only cases suitable for mediation are civil matters. In the children court, divorce matters, but as it is, the judiciary is not dealing with criminal matters under mediation. We're only dealing with civil matters.
All right. Now, this initially was introduced as a pilot phase in the family and commercial divisions of the court. How much so far in terms of gains have we seen from that pilot project? There's
been significant gains in terms of the amount that has been settled and recovered back to the economy. There's been significant gains in terms of the settlement of family disputes, in terms of restoring the family back together.
Right.
Yes.
But also important, Michelle, is that mediation gives closure.
Yeah.
In most criminal processes, even if somebody has been convicted and served sentence, you realize that even when they're coming out of prison, it's still very difficult to integrate with society. If someone has committed an offense in a community and is jailed, coming back again is so difficult to be accepted by the community.
Right.
But in mediation, it's the closure. There's closure immediately. There's a settlement.
But what happens when one wants to opt out of the mediation process?
So basically what happens is mediation is a voluntary process, number one. So no one can implode on any person that they must go through mediation. If a party feels that they don't want to go through the process, for example, let me say the matter is in court and the party has been given a mediator, an appointed mediator, then one of the party feels like they don't feel comfortable with mediation, they can still go back to the court and the matter will still go through litigation instead of mediation. So it's voluntary, it's not...
And then, I actually have a viewer here on Twitter asking, can one use mediation proceedings to my disadvantage? Can this happen?
No, because number one, you need to understand that the mediator in any given matter has to be impartial, and whatever is discussed in mediation sessions is very confidential. It cannot even be used as evidence in any court. It has that high level of credibility in terms of confidence, and so it allows parties to come up with their own solutions.
Right.
They are not imposed as in the court system. So then it gives parties a chance to talk and come out with a solution which is a win-win for both of them. That is not disadvantageous to any of the parties.
Right. My next question will be, how then will that agreement be enforced legally? Will it be filed somewhere? In just a moment. But initially, when you talk about mediation, we're discussing court-annexed mediation.
Yes.
But mediation has been happening in our communities and in our societies since time immemorial. And many would think then that's the kind of mediation that they should use. Call the chief or the clan elder to come and negotiate a process. But how different are these two, Wafula, in terms of how binding they are?
I think what the Constitution and the government has tried to do is to legalize that process. Remember, there was a long time ago the out-of-court settlement, where you would appear before the magistrate would actually tell you, go outside and agree, and come and tell me what you have agreed.
Yeah.
So which means mediation, in a way, existed from long time ago. But it's been... As you've asked him a question, how it can work on somebody's disadvantage, it's been abused. Mostly the process has been abused.
Right.
People agree and they don't honor the agreement. Somebody agrees that I will pay you this amount of money. If we agree, withdraw the case. Once you've withdrawn, the person doesn't pay. And you cannot go back to court with the same matter. So some people have really taken advantage of others. And I think that's where the legalization process of this mediation process brings in a person who then ensures that nobody's, it doesn't work towards anybody's disadvantage.
Let's discuss, Ofula mentioned something important, you know, after the entire thing, you cannot go back to court with the same case. So then does it mean opting for mediation is, you know, almost a do or die? If the mediation process does not work, then the case is dead?
No, basically what happens is, if parties fail to agree, first of all, let me address that issue of enforcement. What happens when an accredited mediator is appointed to a case and the parties helps the party to reach a settlement? Yeah. Once they reach a settlement, that settlement is filed in court and is adopted as a judgment of the court.
Right.
So it's as good as any judgment that is issued by a magistrate or a judge in the court system. This goes to help the parties have faith in the process and also ensures that it's legally binding so that a party cannot opt out of that process easily. Secondly, mediation has no appeal process, unlike the litigation process.
Right.
So the only option that is there for mediation, when the talks fail, the matter is taken back to court. So what a mediator does, he applies to court and writes a report to the court and says the party did not settle this matter. In that case, the matter will be taken back to the court system and it will undergo the normal litigation process.
Right,
Yes.
right. Let's talk about the fact that now the judiciary is in the process of rolling out court-annexed mediation to all the 47 counties or to other counties other than the pilot counties. Ofula, what impact do you see this having, say, in the next 3 to 5 years?
I think what will happen is that we expect to see a reduction on the backlog. To see, like I saw yesterday, the president of the Robert Ouko going to Kisumu and saying that there are a lot of people in pre-trial, seeing some of these people being released and maybe their cases being sent back to mediation. But also there's a confusion. I think this is very important, is that most lawyers undertake mediation on behalf of their clients without actually making it known that it's mediation. And you see lawyer party to party meeting and agreeing and then reaching a settlement and telling the client that this is what I think the other lawyer agrees, and they solve this matter. So I think we need to understand also that what's the level of mediation that we are talking about, because the court-to-court mediation that we are referring to, where there's an expert appointed, is so different from where lawyers sit and agree among themselves and they're representing two entities, and they're able to still solve the matter or not even solve the matter and go to court again for the thing. So I think from a legal point of view, I think you need to educate us and understand what happens when two lawyers agree on a matter that involves two clients and reach a settlement.
All right, let's take a short break now. We'll come back with this conversation. We are discussing court-annexed mediation as an option or the dispute resolution mechanism as opposed to going through the rigorous court process. In studio, we have analyst Evans Ofula and lawyer Caleb Kusienya. On our Twitter poll question, we're asking you, would you opt for mediation as a means of dispute resolution? Do speak to us. The hashtag is KTN News Center. The conversation continues after this break.